Mr. Kahan should be number 79 on the docket, Your Honor. Your Honor, at this time, I want to ask the court to continue both 24 CF 1393 and 24 CF 2758. We are in the middle working through depositions, and I think after some of the depots, it's apparent the information should be amended to reflect more appropriate charges, so need time to review that and then set those depots.
All right, are the depots set?
They're in my office, Your Honor. Normally I would have a date, but I don't have one yet.
Okay.
That's without objection, Judge.
All right, so 24 CF 1393 and 24 CF 2758 will be continued at the defense's request, and that will be April 16th for both cases.
Michael Green.
24 CF 2534.
You know, this is going to be with Ms. Basso. I'm assuming she's coming back.
She is.
Should we pass Mr. Green until she?
Unless we would plan on continuing it, I've got eval that's coming in.
If it's based on an eval, that we would not have any objection.
If we can continue Mr. Green's case to April 16th, but my suspicion is once I get the eval in, I'm going to move him to a date in March.
Absolutely. So for now, we will continue the case till April 16th, and of course, if you need to bring it in early, then by all means we
Yes,
will.
sure. We will do that.
Okay, thank you.
Your next is going to be Mr. Pablo before the court in 4 cases.
2018 CF 2511, 2021 CF 1038, 2024 CF 679, and 2024 CF 2713.
Yes, Your Honor. We have done our first round of depositions. I was hoping that would be enough to potentially get an amended offer. The state has instead continued with the same offer, so we would ask the court to continue the case. I'll schedule the rest of the depositions and then look at filing a potential motion to suppress at that point.
Okay, I do see that the 24 CF 2713, the new law case, is practically brand new, so.
Yes, Your Honor. We just did our first round of depositions on January 14th, so I've got, I think, 2 other officers I need to depose, and then my intent is likely, if the state isn't going to make an amended offer, to file a motion to suppress.
All right, any objection?
No objection, Your Honor.
All right, so we will set all of Mr. Hill's cases for April 16th. And I know, Mr. Gates, if you need to bring it in sooner for anything, you will
Yes,
do
Your
so.
Honor. That would be my intent.
Thank you.
Your last inquest we have on the docket today is going to be Mr. King. If I can the record reflect I'm giving Mr. King a copy of his paper discovery? He'd asked for that yesterday.
All right.
It is, first time up, it is a case in which the state is seeking DOC. Guidelines are under 44. If we could continue Mr. King's case, I'll look to start scheduling depositions as well.
All right, any objection from the state?
No, Your Honor.
All right. Continued at the defense's request. Do you want to put this on the, should I put it on the 14th or the 16th?
Okay.
14th or the 16th?
The 16th, Your Honor, if we could do.
April 16th?
Yes, Your Honor.
Thank you.
We have Steve's,
We have his 2, yes. Okay, I can do that. Alderman and Alaway? That's fine. JJ, can we get 65?
that concludes my business before the court, but I'll stay in case we need some help or coverage.
Thank you. All right, Mr. Medina, are there some cases of yours we can take care of?
There are 2 inmates with the letter A.
All right.
Alderman 4, female
Garcia, male. Male now, Your Honor.
Wonderful,
Both
thank you.
continuances. They were the only two from the letters A and B that were here this morning, so. Just the fate of the alphabet that had to inconvenience the statewide prosecutor all day. I apologize for that, but
Well,
don't really control it. But still feel bad about it. I wish I'd thought about it yesterday. I could have given him a heads up, but I just didn't think about it. Your Honor, Steve Medina with Carly Alderman Ford. Ms. Ford's cases pending in Division 1. There are 3 new law cases, 22 CF 2665, 23 CF 2176, 22 CF 2927. I may have to approach regarding this situation, but there is a third case, a 25 CF case that's pending in Crestview Division, and then I've been pointing out probably needs to get transferred to Division 1 to go with the other 3 law that are older. I have done substantial work on these 3 cases. There's also some special background that I could refer to the court if we approach, but I could just tell the court that given that there's a 4th case, I've discussed that with the Crestview public defender. There's not a conflict because we conflicted off a co-defendant, so I presume it's a matter of days, if not weeks, that we'll get that in Division 1. So we probably need to continue these cases to the April pretrial.
any objection from the state?
No objection, Your Honor.
And I will say to the court that in addition to doing what I can on the 25 CF case, I'll be making sure that everything's as far along on these 3 older cases as well.
All right, so,
Hopefully all the discovery had already been done in those 3 cases, Judge.
okay, any depots that you know of that still need to be taken in the?
No, but I will verify. I didn't as completely closely scrutinize that as I will in the next few days. I did try to take a fairly good look at it a couple days ago, but I want to make sure, given that we're going to have a continuance, that everything's done in the 3 older cases.
Absolutely, because I know there's a new case coming, but,
Right.
you know, a couple of these are
They're quite old.
really old.
And there's a lot of history here, but I'm not going to take the court's time unless you want me to.
Do you think you'll be ready to go next cycle on any of them?
I would imagine there won't be any impediments in the 3 older cases, Judge.
Okay.
And I got to see what the global situation is given the new ones. So.
Will the state be ready next time on any of the older cases?
Yes, Your Honor, the state will be ready.
All right.
Can I approach? I do. I think
Yes.
it's important that
Yes.
court knows something. Can she come as well, my client?
Yes.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
All right, so on the 2 oldest cases, those are 2022 CF 2665 and 22 CF 2927. Let's be ready to go next time. This last
Yes, Your Honor.
continuance.
And that court date for out of custody, for inmates is that 4/16?
April 16th for all four well, I guess the new case will be coming. The 2025 case will be coming, but we'll go ahead and put April 16th on the three that are in the division currently.
Yes, Judge. And I wrote 1 PM because that's customarily where the,
Well, she'll be in,
no, because it's today, so it's 9 AM. I'm
yeah,
sorry,
she'll be
Judge.
in custody, so she'll be brought whenever.
Yes, Judge, I'm sorry,
No problem.
I don't have the new procedures down.
No problem.
you.
And as to the two 2022 cases, this will be the last continuance. We need to gear those up.
Yes, Judge.
All right. Thank you, ma'am. I'll see you in April.
Your Honor, Takia Alloway's before the court approaching. I met with him yesterday. His case is 24 CF 1744. The defendant has filed a dispositive motion to suppress that's set for March 20th. And then there's a chain of custody issue that I didn't want to wait until March on, so I raised that in a defendant's motion to compel that's set for docket day. It's just going to be a short thing about some documents that we think need to be produced. So we can have that discussion if you can return on docket day for a plea or continue. And then more than likely, everything is going to get continued out from there to March 20.
I also show that Mr. Allaway has another case, 24 CF 1306.
Yes, Judge.
Okay.
That case is pretty mature. I'll make sure that that's ready to go next cycle if need be.
Okay.
I think the way things were going was that was going to be a pretty easy case to resolve. And then he picked up a bigger case, which is the subject of the motion to suppress. So I think a resolution of the older case will be probably forthright if we don't have as big of a global situation.
Okay, so we will set both cases for docket day, February 17th. That's this coming Monday.
Okay, you can do that then, right? You're coming back Monday. Okay, thank you.
Your Honor, I believe that we're going to call one of my out-of-custody clients,
All right.
Tyrone Clayborn, 24 CF 2798. He is present and approaching. Your Honor, I've spoken with Mr. Clayborn. We have started to get some discovery. At this point, Mr. Clayborn would like to proceed to trial. The defense is ready to go.
Okay. State?
The state's ready.
Okay, great. So I will set the case for docket day, February 17th. That's Monday at 9. Has the state made an offer?
Yes, I do have the offer from the previously assigned state attorney, so I don't know if the offer would change, but I do have a offer.
State, have you made your
Yeah,
best
I have.
offer?
Yes, the state has made its best offer at this time.
Okay, so Mr. Claiborne, I've set your case for February 17th. That's Monday at 9 o'clock. That'll be the last day I'll accept a negotiated plea. You understand, sir? So on that day, I'll ask the state to put their offer on the record, and I'll make sure that you understand it and make sure that you are fully informed. So both sides ready for trial. State, go ahead and subpoena your witnesses, and we will proceed forward, and I'll see everybody February 17th at 9.
Thank you, Your Honor.
Thank you.
Sure. One second, Your Honor.
Thank you. I believe this is Ms. Basso's case. I don't see Ms. Basso. Almost positive this is Ms. Basso's case.
Yes, this is Ms. Basso's case. Okay. Thank you. If I could have 1 second with Mr.
Sure.
Carrasco. If we could bring him back out in a minute, I got some additional information from probation, and I want to make sure Mr. Carrasco understands, because likely he's going to be accepting a plea today. So I just want to make sure he understands what will happen when he serves.
Yes, and I think we need to wait on Ms. Basso anyway.
Okay, I
so,
appreciate that.
Yeah.
Thank you. I'm going to come back and talk to you again, to make sure you got it. Thank you. Your Honor, next up is Israel Chartrand, 24 CF 2293. He is present and approaching. The state and the defense have reached an agreement here that I actually need the state to sign, as well as Mr. Chartrand. Sorry, do you want the first one?
Whichever one you want me to sign.
Here you go, sign right there, please. Yeah, do you want to sign on the bottom?
Yeah, I'll sign
Yep.
on the bottom.
Sorry, my bad.
No, you're fine.
Okay.
Thank you. I was a little nervous, but it's okay. This is the same one that we
Your Honor, I have a score sheet and the plea agreement, if I may approach.
Yes, of course. Thank you. Thank you so much.
Mr. Chartrand has one case, 24 CF 2293. There were 8 counts originally charged. Per the plea agreement, counts 1, 4, and 6 will be dismissed by the state. Counts 2, 3, 5, 7, and 8 will be adjudications of guilt. Counts 2, 3, and 5 have concurrent 30 months probation. I put the terms of the probation just in the one count for the reasons that we kind of discussed the other day. So substance abuse evaluation within 60 days, begin any treatment, recommended treatment within 90, mental health evaluation within 60 days, and begin treatment within 90 days. I did specify there at somewhere like Baptist Behavioral Health Unit or similar. Mr. Chartrand he's wanting to go there. That's a location he's familiar with. No violent contact with the alleged victim who is named there. Batterers Intervention Program, $967 in court costs, $150 public defender fee, and waive the cost of probation.
Probation, are you okay with waiving the cost of supervision? Yes. Okay. And batterers intervention, that's a 29-week program.
Yes.
So if Mr. Chartrand doesn't start it in a timely manner, he's not going to be able to finish, he's going to violate. So what deadline would you like to put to start the program?
I know that sometimes they get backed up, but maybe make the appointment within 30 or 60 days, something like that.
Or
I don't know if
longer,
the
I
state
just-
has a preference.
Yeah, if he,
But at least to call and have an initial appointment within 60 days, I think would be sufficient. If the state is okay with that. Okay. No objection to that, Your Honor.
okay. Why don't I put on here commence within 120 days? It gives extra time.
Yes, thank you, Your
That
Honor.
way, Mr. Chartrand, you can go ahead and get started because it is a lengthy program.
Yes, ma'am.
And if you wait too long, you won't be able to complete it in time, and you could violate your probation by not completing it. It appears this is a downward departure. Is that the state's request? Or
Yes, Your Honor, this is a legitimate uncoerced plea agreement. I thoroughly went over this with the victim, and it concedes exactly what the victim was wishing to happen in this case.
Okay, so the victim is in agreement with this?
Yes, Your
This
Honor.
agreement? Okay. Mr. Chartrand, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do. Thank you, sir. Could you state your name, please?
Israel Chartrand.
Thank you. Sir, you are charged with 8 different offenses: tampering with a victim, grand theft auto, possession of a controlled substance, fraudulent use of a credit card, fleeing or attempting to elude, felony battery, violation of a domestic violence injunction, and driving while license suspended or revoked. Have you had a chance to talk to your lawyer about all of those charges and any possible defenses?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the plea agreement?
Yes, I did.
Is this your signature in the middle of the next to the last page?
Yes, ma'am.
Do you understand the rights you give up when you enter a plea?
Yes, I do.
Is anybody forcing you to make you enter the plea today?
No, ma'am.
Are you satisfied with the services of your lawyer?
Very much so.
That's good to hear. Have you had any drugs, alcohol, medicine, anything in the last 24 hours that affects your ability to understand what you're doing?
No, ma'am.
I do have a score sheet. It shows 48.6 total sentence points. Any objections or corrections?
No, Your Honor.
Any DNA?
Not that I'm aware of, Your Honor.
I do find a sufficient factual basis based on the arrest report. Sir, if you're not a U.S. citizen, do you understand that the plea could subject you to deportation?
Yes, ma'am. Okay.
All right, how do you plead to counts 2, 3, 5, 7, and 8?
No contest.
I accept your plea. I find it was freely and voluntarily entered. Does the state have an announcement on counts 1, 4, and 6?
Your Honor, the state will be null crossing those counts in exchange for the pleas of the others.
Thank you. Sir, I'm going to adjudicate you guilty of the counts that you pled to in accordance with your plea agreement, and I will sentence you as stated on the plea agreement. On counts 2, 3, and 5, that's grand theft auto, possession of a controlled substance, and fleeing or attempting to elude. Those are the 3 felony counts. There will be an adjudication of guilt, 30 months, that's 30 months probation. All counts will run concurrently with each other. You must complete a substance abuse evaluation within 60 days and begin any recommended treatment within 90 days and successfully complete that, whatever treatment they recommend. You must have a mental health evaluation within 60 days, and then you must start treatment, if recommended, within 90 days at Baptist Behavioral Health Unit or a similar facility. You are to have no violent contact with Bridget Fair, F-A-I-R. That means no acts or threats of violence. And you must start a batterer's intervention program within 120 days, and you must successfully complete it. There will be $967 in court costs.
It's actually going to be $648 because the battery charges are being discussed.
Oh, thank you.
$648 in court costs. That will help with the cost of the batterer's intervention program. $648?
Yes, sir.
Okay, great, thank you. With $150 public defender fee, that includes the $50 application fee, and probation was kind enough to waive the monthly cost of supervision. That will also help with your batterer's intervention program costs.
Thank you.
So on counts 7 and 8, there will be an adjudication of guilt and sentence to time served, credit for time served on those 2. Did I leave out anything?
I don't believe so, Your Honor.
All right. You have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you, and good luck to you, sir.
Thank you.
Thank you.
Mr. Quester's next.
Your Honor, Christopher Cluster, 24 CF 2759. There is a psych evaluation pending in a misdemeanor case that he has with my colleague Allison Tringus. So I'd like to continue this case just to track that one as soon as we get that evaluation back. I didn't want to request a redundant one in this case. So when we do get that evaluation back, if there's an earlier court date to be had, then we will of course schedule it. But if we could do it for the April pretrial conference, just to be safe.
All right. Should I put this on the 14th or 16th?
I believe the 16th for now, and if he does bond out, then I'll make sure that
He
your
could still-
office.
He could still come on the 16th?
Yes. Thank
Okay,
you.
and the evaluation, just be sure you file it at this case, once you get it back in the other case. So, Mr. Cluster, 24 CF 2759, we will continue that to April 16th for pretrial.
Thank you, Your Honor.
Mhm.
I'll come see you at the jail.
Jesse Cooley.
Your Honor, this is Jesse Cooley, 24 CF 2535 and 24 CF 2788. I am waiting on an updated offer from the state attorney after he picked up the second case. I don't yet have an updated offer, at least I don't think so. And Mr. Cooley has been accepted to a treatment program, so I'm hoping that we can work something out at the next pretrial conference, if we could have a full cycle continuance.
Do you think you will have an updated offer prior to Monday?
Honestly, I don't think we'll be able to get anything resolved before Monday. We might be able to before the March date. I have no objection putting them on there.
Okay. That
So
would be
it's at
fine
least
with
not a full cycle.
Okay, so maybe March 18th?
Yeah, that'd be great.
All right. March 18th, that's miscellaneous day, but we'll be hopeful that maybe there's a resolution.
Bye, Mr. Cooley.
William Crandall.
Your Honor, this is William Charles Crandall, 24 CF 1977 and 24 CF 1110.
Yes.
I've been back and forth with the state attorney on this case quite a few times. We'd like to put it on for docket day for a hopeful resolution.
All right. We will set the case for February 17th, docket day, 9 o'clock, for hopefully a resolution.
Thank
All
you.
right, thank you.
Lamar Davis.
Twenty-four CF 2734.
Yes. Apologies, Your Honor. This is the first pretrial conference up, and Mr. Davis was rearrested before I was able to meet with him, or I guess was arrested in this case. So if we could have a full cycle continuance so I can have time to go meet with him at the jail.
Without objection.
All right, is there another case that's pending or coming?
That's my understanding, Judge. It hasn't crossed my desk yet, though. Or
Okay.
it might have, but I have not put any effort towards it.
Your Honor, my client is informing me that he'd like to take the state's offer if the offer is still the same. It was an adjudication of guilt and 2 years probation. If we could maybe bring Mr. Davis back out in a minute so I can confer with the state and see if that's still the offer.
Yes, I'll look at both cases and see
Okay.
what I need to do to.
Okay, then
get it
we'll
resolved.
recall Mr. Davis in a few minutes then.
Thank you, I appreciate it.
Oh, okay, thank you. The new case is a misdemeanor.
Okay,
That's why I wasn't assigned.
so it'll be, yeah, it'll be
We
the
wrap
same.
it in misdemeanor.
As long as it's not DUI or. I'll look at it.
Yes. Gonna be Troy Dowd.
This is, oh, that's Mr. Dixon.
Oh, sorry.
Mr. Dixon?
All right, good, how y'all doing?
Okay, stand right here.
Okay.
All right, this is Kirby Dixon, 23 CF 816. Oh, sorry. Your Honor, we conducted depositions in this case late November, but two very important deputies who were served did not show up. No explanation, I'm not really sure why. So I need to depose the two of them. We also just finally received FDLE in count 2 in December. So I know the case is getting a little bit old, but with the nature of the charges, I would like a full cycle continuance, please.
Any
Without objection.
All right, so if people who are subpoenaed don't show up for depots, file a motion for me to address it. We will reset the case for April 16th at 9 o'clock.
Thank you, Your Honor, I
Thank
appreciate
you.
it.
April 16th.
I'll come see you at the jail, This is Troy Data, 24 CF 2281, excuse me, and 24 CF 2153. Your Honor, we conducted quite a few depots in both these cases, the end of January, beginning of February. We are this close to a resolution. If we could put it on for docket day, I am very optimistic that we will resolve both cases.
That is great. February 17th for docket day with a very hopeful resolution.
Layton Duffy.
24 CF 2706. Any word on the bus with the inmates?
Judge, they're here, I'm just currently waiting for you to
Yeah, that's
So
charged.
I already spoke to the prosecutor,
Okay.
and he is available.
Wonderful. Thank you.
Yes, ma'am.
Your Honor, I apologize. This is Clayton Duffy. I believe that my client has picked up a new charge at the end of January. So if we could have a continuance so I can speak with the state attorney about a potential global offer.
Any objection from the state?
No objection.
We say probation or something.
For the new.
Yeah, probably not. I didn't know if we could put it on the March.
It's what? It's a Crestview.
Oh, the
case.
new one is a Crestview case? Okay. Is there any way to know if the case will be transferred down here or if it will remain a Crestview case? Okay. Okay, so I'll speak with the state attorney if we could leave it for the April date for now, and I can always schedule an earlier court date if we're able to work it out.
All right, April 16th.
Next is Pablo Estrada.
So Mr. Duffy will be on April 16th docket.
Thank you. Next up is Pablo Estrada-Sola. I have an interpreter here. Mr. Estrada-Sola will be entering a plea.
All right, looks like he has two cases.
Yes, I'm sorry, 24 CF 849 and 24 CF 850. So I just want to have Mr. Estrada-Sola sign the plea agreement.
Okay.
This one is. Mhm. Mhm.
Is that to get out?
So.
And what was the community one?
So. Your Honor, I had reviewed the offer with an interpreter with him at the jail, but I just wanted to make sure that we were all good.
I understand.
And I have a score sheet as well. Great. That I will provide with the court. Provide the court with, sorry. Okay. If I may approach.
Yes. Thank you.
All right, Your Honor, there are two cases here. I'm going to pass a plea agreement to the, to probation so that they have a copy. In 24 CF 849, there were 3 charges. Count 1 will be adjudication of guilt to the lesser, oh, sorry, I'm talking too fast. Adjudication of guilt to the lesser included offense of robbery by sudden snatching. The statute is 812.131, subsection 2, subsection A. 1 year community control followed by 1 year probation that will run concurrent with count 3. 515 in court costs, $150 public defender fee, waive costs of probation, and the state will reserve restitution for 90 days.
That is correct.
Count 2 will be dismissed. Count 3 will be an adjudication of guilt and the same terms of probation, 1 year community control, 1 year standard probation to follow, or to run concurrent, I'm sorry. 24 CF 850, count 1 will be dismissed. Count 2 will be an adjudication of guilt to the misdemeanor possession of paraphernalia, credit for time served, the misdemeanor court cost of $270, $100 public defender fee, and I put the 24 months to pay, which would essentially be the term of probation in the other case.
All right. Probation, are you okay with the agreement to waive the cost of supervision? Okay. Sir, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Yes.
Thank you. You can put your hand down. Could you state your name, please?
Pablo Estrada-Sola.
All right, sir, in case 24 CF 849, you are charged with 1 count of robbery with a deadly weapon, 1 count of aggravated battery with a deadly weapon, and 1 count of grand theft. In case 24 CF 850, you're charged with 1 count of possession of a controlled substance and 1 count of possession of drug paraphernalia. Have you had a chance to talk to your lawyer about those charges and any possible defenses?
Yes. Ya hablé con él.
I spoke to her.
Did you discuss the plea agreement with your lawyer?
Sí. Yes.
Yes.
I see that the plea agreement is in English. Did someone read the plea agreement to you?
Ella siempre lleva una traductora ella.
She always brings an interpreter with her.
So we went over the plea agreement at the jail.
Is this your signature on the last page of the plea agreement?
Yes.
Did the interpreter who went over the plea agreement with you and your lawyer explain the terms to you?
Sí.
Yes.
Do you understand the rights you give up when you enter a plea?
Yes.
Do you understand you're giving up your right to have a trial?
Derechos de ir a juicio. Yes.
Are you entering the plea freely and voluntarily?
Libre y voluntario.
Yes.
Yes.
Are you happy with the services of your lawyer?
¿Está contento con los servicios de su abogado?
Sí.
Yes.
Did she answer all of your
¿Le contestó
questions?
todas sus preguntas?
Yes.
Have you had any drugs or alcohol or medication in the last 24 hours that affects your ability to understand what you're doing?
¿Lo que está pasando?
No.
I have a score sheet that shows 30.2 total sentence points. Are there any objections or corrections?
No, Your Honor.
Ninguna.
Any DNA?
No, Your Honor.
I do find a sufficient factual basis based on the arrest report. Sir, do you understand that if you are not a U.S. citizen, this plea will subject you to deportation?
Puede estar sujeto a deportación.
Yes.
And how do you plead to the lesser included offense of robbery by sudden snatching as to count 1
Como cargo uno.
of 24 CF 849 and count 3 grand theft?
No contest.
All right, and in case 24 CF 850, how do you plead to count 2 possession of drug paraphernalia?
Equipo para drogas.
No.
No contest.
I accept your plea. I find it was freely and voluntarily entered. Does the state have an announcement as to count 2 in the case ending in 849 and count 1 in the case ending in 850?
Yes, Your Honor, we are no crossing those cases for a plea to the other ones.
Thank you.
Por aceptar la declaración a los otros cargos.
Sir, on the lesser included offense of robbery by sudden snatching, is that a third-degree felony, attorneys?
Yes, Your Honor.
Okay. Which is a third-degree felony. I am adjudicating you guilty of that offense, and I am sentencing you in accordance with your plea agreement to 1 year of community control. That's like house arrest,
Como arresto domiciliario.
followed by 1 year of probation.
De probación.
$515 in court costs,
$5 en costos a la corte.
$150 public defender fee. The court will reserve jurisdiction on the issue of restitution for a period of 90 days.
Costo de restitución por un periodo de 90 días.
Probation has agreed to waive the cost of supervision per month.
Supervisión por mes.
As to count 3,
Cargo número 3.
grand theft, that's a third-degree felony, adjudication of guilt,
Declaración de culpabilidad.
1 year of community control followed by 1 year of probation,
De probación.
concurrent with count 1.
Juntos con el cargo número 1.
In case 24 CF 850,
850.
count 2,
Cargo número 2.
possession of paraphernalia, that's a first-degree misdemeanor, adjudication of guilt,
Declaración de culpabilidad.
credit for time served,
Y crédito por el tiempo que ya se vivió en la cárcel.
$270 in court costs,
$270 en costos a la corte.
$100 public defender fee.
Costo de la defensa pública.
I am going to require the defendant to see the clerk within 30 days to get on a payment plan.
Y le voy a
Yes,
pedir
Your
que,
Honor.
por favor, se ponga con la
With a
secretaria
24
de la
months
corte
to
para que haga
pay.
un plan de pagos. Tiene 30 días para hacerlo.
As long as he's on a payment plan.
Yes, Your Honor.
Okay.
I figured that was easiest
Yeah.
just because he's on 24 months of supervision, so just kind of tracking it.
Para lo de probation.
Your Honor, just for the record, I'm going to inform my client that if he's not brought back to the jail, or if he's not released from the jail in time to meet with probation today, then it'll have to be first thing in the morning by, what, 8? 9:30, before 9:30 tomorrow morning.
Antes de que usted salga de la cárcel, usted tiene 24 horas para ponerse en contacto con probación.
Okay.
All right, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I will appoint one for you. Good luck to you. Report to probation first thing in the morning, 9:30, no later.
Wait, finish next.
delineated, I struck through the 4 and 5 in paragraph A of paragraph 6, subparagraph A. I also, with discussion with the statewide prosecutor's representative, Mr. Vallejo, we added some time served language that we've been negotiating for a number of weeks, if not months, to make sure that basically he's going to get all his time served. For the court to have the background is that my understanding is he was arrested in Okaloosa County in relation to this, what is a statewide RICO action, on or about June 2, 2023. He posted bond, but before his feet hit the pavement, he got picked up on some sort of Kentucky hold or something. He went to Kentucky, at least 2 counties in Kentucky. He was found, he pled out, is my understanding, in 2 counts in Kentucky, and he's gonna get all the time served. And I'll go over the specific language, and I'm sure the court will too, but basically the intent is that he's getting all his time in jail here, being transported from here up to Kentucky, all the time moving around in Kentucky, and then back to here, and then he's been back here for a few months. He's getting all his time as part of his time served. And so I added an asterisk, time served shall include all time served in jail on this case, and I added a parenthetical, notwithstanding bond status, and I did that because technically when he came back from Kentucky, in fact, when he went to Kentucky, he was technically out on bond, so we didn't want to get him stuck in a situation where he didn't get credit for all that time because he's technically standing before the court with bond on this case. So despite notwithstanding his bond status, he's going to get all this time. Transportation time and time related to this case and all time served in Kentucky jail, transport, and prison relating to the cases referenced in paragraph 6C, which is the next paragraph, and that refers to Kentucky felony case 23 CR 391 in Fulton County, Kentucky felony case 23 CR 00027. Now I will go back to what is really the deal. The deal is really that he's going to do 60 months, which is 5 years DOC. It's 60 months incarceration with the Florida Department of Corrections on counts 1, 2, and 3 with credit for all time served, and that's concurrently with all those counts among each other. I know that's the intent.
Yes,
right.
yes, Your Honor. And just for clarification, we had to extradite Mr. Briceag to the interstate agreement on detainers, which is why he's still in custody. It's my understanding after, and I spoke to my supervisor, my initial thought was that he was going to be sent to DOC to be sorted by classification and then be sent. But apparently because he is on loan technically from Kentucky, Kentucky might very well just pick him up in a week or so, because he did plead, I believe, to 9 years total in 2 cases in the Commonwealth of Kentucky.
And I do not have I'm not a member of the Kentucky Bar. I've provided no advice as to Kentucky issues or time. He does have certain understandings that may or may not be correct about what might happen in Kentucky, but I'm not warranting what might happen in Kentucky. But whatever time he does serve in Kentucky, it is going to count toward the time here, and that's what's critical. This is a downward departure. The court will see in the score sheet, which we're not contesting the score sheet, but it does have a downward departure. I believe it's 71.7, if I'm not mistaken.
That's the lowest permissible
Yes.
sentence.
And I explained to him that if he were to go to trial and lose, the court wouldn't be limited to that. The court could actually exceed that. He would have, I believe it's, is it 90? He would be in peril for 95 years. And furthermore, the court would not be obligated to give him concurrent treatment with Kentucky. So this agreement is very beneficial to him. I'm recommending that he take it, and he's accepted my recommendation.
All right, a couple of questions. First of all, I do see the $500 reduced cost of statewide prosecution, but let me see if there are any other court costs.
Your Honor, I may not have signed my acknowledgement too. I apologize.
That's okay, and I believe...
I've been looking at it, but I didn't sign it.
Here you go. Let me hand it back to you.
I'm sorry, Judge. I
No problem. No problem. Come on and get this because...
Okay.
Well,
Oh, you didn't?
yeah.
Okay, I thought you'd sign. I'm sorry, man.
And
Ready to sign?
what are the costs? $515 and that's it? Okay.
Yes, and I do need to also state that we would get the 150 public defender fees, including the $50 application to the clerk. I'm sure the statewide prosecutor doesn't object. But let's see, Judge. May I push?
Yes,
Apologize.
no problem. Thank you. On the proposed order for cost of prosecution, do I need to include the other court costs in here?
No, Your Honor.
Just-
That's just a specific order that my office likes just for record purposes.
Okay, thank you.
May I just, I'm going to mute and just make sure he understands the costs that are, there's a couple more costs that are being added. So.
And the state does not object for the cost of prosecution to be turned into a judgment given the circumstances.
Okay, thank you.
Thank you.
All right, sir, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir.
Your Honor, I apologize. There's multi-layers of complexity, and I wanted to mention at the outset a couple things that I'd forgotten. First off, is that my understanding is, and I'm sure the court is going to have some standard questions as to if he's not a United States citizen. We have every reason to believe the state is represented that he's not a United States citizen. There is an expectation, none of which is controlled by anybody in this courtroom, that he will very likely be deported at the completion of any prison time. But I've explained to him specifically that in addition to the items that are spelled out in the agreement that have federal citations to being deported, I've explained to him that these charges that he's pleading out shall subject him to deportation based on the nature of these charges. That doesn't mean I know what will happen, but he is subject to deportation. Thank you.
Thank you.
Just to clarify that issue, Your Honor, I also don't have a crystal ball. I can say that the defendant does have a current ICE hold, and it's part of the reason why the offer didn't include probation, and the state feeling, discretion, the discretion being the better point of valor at this point. The state expects, while we don't have a crystal ball, that after he serves the Kentucky and Florida time, that he will most likely be deported.
Thank you.
I think that is my last interruption. I'm so, Judge, I apologize.
No problem. All right, sir, I swore you in a minute ago. Could you please state your name?
Briceag, Basil Sereno.
All right, that sounds different than what I'm seeing on.
As I explained to the court, we have to, in this case, on the pleadings, put the spelling that the clerk used. I did indicate Kentucky spelled his last name Briceag. And I think he's saying that the way he pronounces it is more in tune with what Kentucky spelled his last name, Briceag. Is that the way you would spell it?
Yeah, that's the right name.
Okay. Romanian is your native language, right?
Yes.
Do you use a Cyrillic alphabet or like a Roman alphabet, English alphabet?
English.
Okay. So you spell it Briceag?
Yes.
So that's, Your Honor, we can do AKA
Okay.
Brickage if you'd like to, but that is a matter of record in Kentucky cases.
And Your Honor, I would refer the court to the information. The information was filed with his full name, Basil Briceag, and also at the last page of the information, where it includes his biographical information, the state included his name in this case caption, but also every known alias he may have. So it would
Thank
cover all his given names.
Thank you. All right, sir, you are charged with five different criminal offenses, and it's my understanding you are entering a plea to 3 of them. And those are racketeering, which is a first-degree felony, conspiracy to commit racketeering, which is also a first-degree felony, and retail theft over $3,000, which is a second-degree felony. The other 2 charges are, that you're not pleading to, if I read this agreement correctly?
Yes.
Larceny, theft, over $20,000 but under $100,000, and petty theft, second or subsequent offense, which is a felony. Sir, have you had a chance to?
Your Honor?
Yes.
Did you want to?
The 2 counts, Your Honor, the last one, count 5, is actually a third-degree felony of use or attempt to use any anti-shoplifting or inventory control device.
Oh, thank you.
Yes.
My docket says something different, so thank
Yeah, I
you for
think the
correcting
docket
that.
may be incorrect. Count 4, as I understand it, was in the state's information as grand theft, 20,000 or more,
Yes.
but less than 100,000. And then count 5 is, as counsel has stated, was use of the anti-shoplifting measure.
Thank you. Sir, did you have a chance to discuss all of the charges with your lawyer?
Yes.
Did you have a chance to discuss with your lawyer any ways you might have to fight the case?
Yes.
Did you talk to your lawyer about the plea agreement?
Yes.
I understand you have some difficulty reading English. Is that correct, sir?
Yes.
Did your lawyer go over the plea agreement with you?
Yes.
Do you understand what the plea agreement says based on what your lawyer has told you?
Yes.
Are there any questions that your lawyer did not answer for you?
No.
Are you satisfied with his services?
Yes.
Did you sign the plea agreement? I'm holding it up.
Yes.
That's your signature?
Yes.
Thank you. Do you understand the rights you give up when you enter a plea?
Yes.
Do you understand you're giving up the right to go to trial and make the state prove the charges against you?
Yes.
Is anybody forcing you or threatening you to make you enter the plea?
No.
Have you had any drugs or alcohol in the last 24 hours or anything that affects your ability to understand what we're doing?
No.
Is English your first language?
No.
Do you need an interpreter?
No.
Are you having any trouble understanding anything I'm saying?
No.
Will you let me know if you need me to rephrase something or if you need an interpreter?
Okay.
Thank you. I do have a score sheet. As we discussed a minute ago, it shows 123.6 total sentence points. Any objections or corrections to the score sheet?
No, Your Honor.
And is there any DNA?
No, Your Honor. Not to my knowledge.
All right. And I reviewed the court file. I do find a sufficient factual basis. Sir, if you are not a U.S. citizen, this plea will subject you to deportation. Do you understand that?
Yes.
How do you plead to counts 1, 2, and 3? That would be racketeering, conspiracy to commit racketeering, and retail theft over $3,000.
Not contents.
No contest.
No contents.
I accept your plea. I find it was freely and voluntarily entered. And does the state have an announcement on counts 4 and 5?
Yes, Your Honor. Pursuant to the terms of the plea agreement, the state announces a no pros on counts 4 and 5 of the information.
All right, thank you. And the court will adjudicate you in accordance with your plea agreement. That will be an adjudication of guilt as to counts 1, 2, and 3. And the sentence will be, it does constitute a downward departure, a slight one, which is based on this negotiated plea agreement offered by the state. 60, that's 60 months incarceration on counts 1, 2, and 3, concurrent with credit for all time served. And Mr. Medina, I see how you had explained this earlier and you wrote it into the plea agreement. Time served shall include all time served in jail on this case, notwithstanding bond status, transportation time related to this case, and the time served in Kentucky, in jail or prison there.
Transportation to and from there. Really.
Transportation to and from, and prison in the cases in Kentucky that you read into the record a minute ago.
Yes, sir.
All right. And as far as costs, there is a $500 cost of statewide prosecution, and standard court costs are $515, and then a $150 public defender fee. Did I leave out any of the terms and conditions?
No, Your Honor.
No, Your Honor.
Okay. And all counts will run concurrently with each other. And sir, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, one will be appointed for you. Good luck to you.
Thank you.
Thank you, Your Honor.
Thank
Thank you,
you.
Your Honor.
Thank you.
This is my only case. May I be excused?
Of course, thank you.
Good luck.
Okay, great. Thank you.
Judge, this is Eric Williams.
Yes,
212.
that is 24 CF 2564.
Yes, Judge, Rudy Harvin on behalf of Eric Williams, 24 CF 2564. At this time, he's going to withdraw his previously entered plea and enter a plea of no contest. This will be an adjudication of guilt, 6 months in the Okaloosa County Jail, credit for all time served to run concurrent. Will be assessed $515 in court costs, $150 cost of defense. There's restitution to Ulta in the amount of $4,231. That is joint and severable with his co-defendants. I've explained to Mr. Williams what joint and severable means. All costs we're asking to be sent to judgment, if I may approach.
Yes,
And that is the state's agreement, Judge.
thank you. Thank you so much. All right, Mr. Williams, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. And if you'll just state your name for me, please.
Eric Martin Williams.
Thank you. You are here on one count of retail theft, $750 or more, in concert with others, that's a third-degree felony, and 1 count of conspiracy to commit a felony, which is also a third-degree felony. Have you had a chance to talk to your lawyer about those charges and any possible defenses?
Yes, ma'am.
Did you have a chance to talk to your lawyer about the plea agreement?
Yes, ma'am.
Did you read and sign the plea agreement?
Yes, ma'am.
Is that your signature on the back of the plea agreement?
Yes, ma'am.
Do you understand the rights you give up when you enter a plea?
Yes, ma'am.
Is anybody forcing you to get you to enter the plea today?
No, ma'am.
Are you happy with the services of your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, anything in the last 24 hours that would affect your ability to understand what's going on?
No, ma'am.
I have a score sheet that shows 28 total sentence points. Any objections?
No objection, Judge.
Any DNA?
Not to my knowledge.
I do find a sufficient factual basis on the arrest report that I reviewed. And sir, if you're not a U.S. citizen, the plea will subject you to deportation. Do you understand that?
Yes, ma'am.
All right. And how do you plead on counts 1 and 2?
Guilty.
No contest.
Oh, no contest.
I accept your plea. I find it was freely and voluntarily entered. And in accordance with your plea agreement, there will be an adjudication of guilt on both counts. And I'm sentencing you, as per the agreement, to 6 months in the county jail on each count, concurrent with credit for all time served. $515 court costs, is that correct? Okay. $150 cost of defense, restitution to Ulta. Do we need an address for that, or? It's in
I think
Destin.
it's the only one.
It's in Destin.
I would say don't go to any Alta in Okaloosa County.
Yes, so stay away from it. Is there a stay away from all Ulta
Yes,
stores?
if it's not in there, it's no trespassing at any Ulta.
Does the clerk need the address for the Ulta for the restitution? Does that have to be in there? Okay.
We have to do a lien.
Okay, so you'll put the address for where the restitution
Yes,
goes in
Your
there?
Honor, my office handles that.
Wonderful, thank you. All right, restitution in the amount of $4,231 to Ulta. That's joint and severable with the co-defendants, and all costs, and the restitution will be sent to judgment, meaning there'll be a judgment against you that will likely affect your driver's license. So
Yes,
it's
ma'am.
important that you get that taken care of. You are to have no trespassing. Stay away from all Ulta stores.
Yes, ma'am.
Did I leave out anything? All right. And, sir, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, one will be appointed. Good luck to you, sir.
Yes, ma'am. Thank y'all so much.
Thank you.
Thank you, Judge. That's all I have this morning.
Thank
Happy-
you.
Your Honor, Donald Huggerson is next, 24 CF 1069 and 23 CF 445. He is present and approaching. Your Honor, we conducted the first round of depositions in November. There were a couple witnesses who we found out about during the depositions that I would like to depose. I am also discussing the case with the state attorney, still hoping to reach a resolution. So if we could have a full cycle continuance, that should give us time to kind of do both.
I am trying to find that on my,
Fuggerson.
what number on the docket?
56 on transport.
Oh. Oh, I don't have it on the,
I was gonna say, 'cause I don't see him on the docket yet. I mean, on my list.
Oops, so sorry.
Oh, did you say Peterson? Yeah, I got 16.
I never have the docket.
The state has no objection to a full cycle continuance.
All right. He is number 74 on my docket.
Yeah.
Got it. Thank you.
Yes.
All right, so you're asking for a continuance to the 16th of April?
Yes, please, Your Honor.
And the state has no objection. April 16th on both cases.
Thanks, Your Honor.
Thank you.
Quincy Fuqua.
Your Honor, next up is Quincy Fuqua, 24 CF 2350. I've been discussing an agreement with the state attorney. We're very close to an agreement. If we could put this on for docket day on Monday, I think we should be able to resolve it then.
That would be great. February 17th, docket day for hopefully a plea.
Thank you. Your Honor, there are a couple of my clients who also weren't transported, so maybe I can address those after we handle Mr. Carasso.
Okay.
Your Honor, this is Nicholas Carasso again. Thank you for the court's indulgence.
Yes, 22 CF 360 and 24 CF 31.
Yes, the state and the defense have reached an agreement in this case. I'm giving a copy to Mr. Carasso. And should I, oh, sorry, I need to have him sign it. Here, can I put this up for you? Yeah.
This is the one?
This one, sign this one.
Okay.
Yeah. Mhm. I can put the date there. And I did not write on there, but I spoke with probation. Would the state be okay with waiving the costs of supervision?
Certainly.
Is that okay?
If the court's comfortable with that, state has no objection.
As long as
Okay.
probation agrees to it.
And there'll be costs on the monitor as well, ma'am, and we'll have no objection to $1 a day.
Okay.
Okay. If I may approach, Your Honor.
Yes. Thank you.
Okay, so in 24 CF 360, that's 2 violations of probation. Both counts will be admissions to the VOP, reinstate probation to complete all original terms, waive the cost of probation, and he will be, as he was before, once again on a GPS monitor at $1 per day, and probation will, of course, instruct him on how to pay that. 24 CF 0031 will be an adjudication of guilt. It's just 1 count of failure to register. Adjudication of guilt, credit for time served, $515 in court costs, $150 public defender fee. I put 24 months to pay, though he is I don't know if it would be easier to put it just the term of his probation in the other case. And that is it. I have also provided Mr. Carasso with the information that he won't be released at the jail until he's seen by probation to hook up the GPS monitor, which will likely be tomorrow. And I also provided instructions after speaking with probation at the top of the plea agreement that I've given him on what he needs to register with the DMV, or sorry, register with the sheriff's office first, then to the DMV and a hotel where he can stay at.
Is there a score sheet?
No, ma'am, I'm sorry, I apologize to the court. We didn't know for sure if we were going to have it done. I will bring it to the court. He does have a 20-year suspended sentence, though, so it was...
Thank you.
He has a what?
He has a 20-year suspended sentence right now, so that is one of the original terms and conditions that will still be imposed.
Okay, can the attorneys approach?
Sure, certainly, ma'am, I've anticipated that.
is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Could the state just file a score sheet within the next day or so?
Yes,
so it's
ma'am, or I
in?
can bring it even tomorrow morning and perhaps hand it to the court directly, and that way we can get it signed if that's
That would be,
acceptable.
that would be great.
I
Do
would-
you have any idea how many points it would be?
I believe I have the old one with me, so it just take me a moment.
Okay.
There. See something? Oh.
And so just for the record and for Mr. Carrasso's edification, the 20-year suspended sentence that was in place in the underlying case is still there. This is what we were discussing, that the state attorney has agreed to this offer, but the 20-year suspended sentence does still hold.
Ma'am, I'll pull that up as the court is imposing a sentence.
Thank
Saw it
you.
earlier, but it's just.
Thank you. All right, sir, if you could please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. And if you'll state your name, please.
Nicholas Carrasso Jr.
Thank you. Sir, in case 22 CF 360, there are allegations that you violated your probation. And also in case 24 CF 31, that's a new law violation. You're charged with 1 count of failing to register, which is a 3rd-degree felony. Have you had a chance to talk to your lawyer about the allegations that you violated your probation and also the new charge of failing to register?
Yes, ma'am.
Did you read and sign the plea agreement?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Is that your signature on the last page?
Yes, ma'am.
Thank you. Do you understand the rights you give up when you enter a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Has anyone promised you anything that's not in your agreement?
No, ma'am.
Are you happy with the services of your lawyer?
Very much so, ma'am.
That is good to hear. Did she answer all of your questions?
Yes, ma'am.
Have you had any drugs or alcohol or anything in the last 24 hours that affects your ability to understand what's going on?
No, ma'am.
All right, thank you. And any DNA?
Not in these cases, Your Honor.
I do find a sufficient factual basis based on the reports I reviewed in the court file. Sir, do you understand if you're not a U.S. citizen, the plea will subject you to deportation?
Yes, ma'am.
Thank you.
And ma'am, the new score sheet will reflect 169 points, which is 105.75 months as a minimum guideline, a maximum of 50 years.
All right, so thank you for that. So this is a downward departure offered by the state.
It is based on, for the original plea, yes, ma'am, and based on the totality of the circumstances and the evaluation, in this case, it is still the recommendation of the state.
Okay. Is the victim agreeable?
Yes, ma'am. We did reach out, and they understand the circumstances. Their main concern was the no contact. And
Okay.
I believe that has not been an issue.
Okay. Sir, do you admit to violating your probation in case 22 CF 360?
Yes, ma'am.
And how do you plead to 1 count of failing to register in case 24 CF 31?
No contest.
I accept your admission as to the violation of probation and your plea in the new law case as freely and voluntarily entered, and I will sentence you in accordance with your plea agreement. In 22 CF 360, probation is reinstated based on the original terms and conditions. You must complete all of the original terms and conditions. Probation has graciously offered to waive the monthly cost of supervision. You will still have to have a GPS monitor at the cost of $1 per day. That must be attached before you are released from jail. You still have a 20-year suspended prison sentence that is still in effect. Sir, if you violate your probation, you are subject to the imposition of that sentence. Do you understand?
20 years.
Yes.
Prison?
If you violate your probation, you are subject to the imposition of that 20-year prison sentence. Do you understand that?
Okay. Okay.
On your
What's 20
original
years?
case?
Prison or 5 years prison?
So, Your Honor, I have explained to my client that there was a 20-year suspended sentence. If he has further questions, I'd be happy to speak with him.
I'll stay with this.
Just for the record, 20 years suspended means that if you violate probation, you could be sentenced to 20 years in prison.
Okay.
This is what we have discussed it previously. I just want to make sure that it's very, very clear.
Okay.
Given the situation of the charges.
Not the 5 years, not, okay. Okay.
That's from your original case, 22 CF 360, when you were placed on probation to begin with.
Okay.
Do you remember that, sir? Being placed on probation to begin with?
I did not handle that case, Your Honor. I believe that was with Brandy Merrifield.
Yeah. I just,
He took that offer in, I believe it was September of 2023.
That's accurate.
Or 2024.
No, it was 23.
yeah, yeah, I agree with what she says.
In case 24, well, let's see, in 22 CF 360, there would be $100 cost of prosecution.
I apologize,
That's
Your Honor.
okay. $100 cost of prosecution. And a $100 public defender fee.
And usually with the DOPs, the client has the term of probation to pay those costs as well. So you have all the time with your own probation.
And then in case 24 CF 31, there will be an adjudication of guilt as charged and credit for time served, $515 in court costs, $150 public defender fee, that includes the application fee, and you need to pay those fines and costs and fees within 24 months. Go see the clerk of court within 30 days after you get out of jail, and they will work out a payment plan with you. Okay?
And I
Yes.
informed Mr. Carrasco that probation will be able to help instruct him on how to pay those costs and everything.
All right. And sir, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I will appoint one for you. Good luck to you.
Thank you.
Thank you.
Thank you.
Mr. Sharp will be next.
What? Those fees? How do I find out? Okay. Thank you. Thank you. Now I do just go.
They're going to talk to you at the check.
Ms. Balso, if you wouldn't mind, I will likely forget, but if you could bring that score sheet so I can sign it tomorrow and get it.
I'm actually trying to work on it right now. I might still get it to you today.
That's fine. Thank you. I'm just worried I'll forget about it.
I'll make sure we get it, ma'am.
Thank you.
Your Honor, this is Javion Sharp.
All right, that's 24 CF 1562, 24 CF 1563, 24 CF 1564, and 24 CF 1685.
Your Honor, we had Mr. Sharp evaluated by Dr. McDonald, and we received the competency evaluation, I believe just a couple weeks ago in January, and I did provide the state attorney with that. I do not know who is assigned to this case at this time.
I think it's gonna be me assigned. I haven't seen the eval because it was probably sent to the previous state attorney.
This one?
If we could approach briefly?
Sure.
Thank you.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Okay, thank you for that.
Your Honor, so, sorry, just back on the record, the defense did file a competency evaluation that was conducted by Dr. McDonald, and I believe that the state...
The state would stipulate to Your Honor considering a report.
All right, the attorneys and parties have stipulated to the court relying on the report from Dr. McDonald. It was filed in the court file. I'm actually looking at 24 CF 1562, so I'm assuming it was filed on the
Yes,
same
I
day in
filed it
all
in all
of
of
them. Yeah, on February 11th. The date of the report is January 10th, 2024. The date of the exam is October 7th, 2024. And the court did review the report, and the court finds that Mr. Sharp is incompetent to proceed and that he does meet criteria for involuntary commitment. And the findings that he meets that criteria are in Dr. McDonald's report, and the court adopts those findings as well and makes those findings. So he will need to be remanded to the custody of the Department of Children and Families
And
for
we
involuntary.
will file an order to that effect. And just for the record, part of the reason that the report, that was essentially the start date for Dr. McDonald trying to evaluate Mr. Sharp. She went back a number of times, and so that's why we didn't get the report until January. So my office will file that order to transport, and we'll go from there.
Yes, and it does, she is of the opinion that he could be restored to competency.
Yes, Your Honor.
Estimated 6 to 12 months.
Yes,
So
Your Honor.
let's set a control date.
Yes.
Maybe 3 months out, or how long would you suggest?
I suppose we could put it on maybe the June pretrial date, because he almost certainly won't be transported immediately anyway.
All right, how
And I can
about
keep an eye on the transport.
June 11th?
Yes, I think that would be fine.
Okay, that'll be a control date or status date, and hopefully we will have gotten a report from the hospital by then to see how he's doing, and I'm sure that if he is restored sooner, then they will absolutely let us know.
Yes.
And we will get Mr. Sharp in quicker.
Perfect, thank you.
So June 11th at 9, for competency status date.
Your Honor, I think we need to bring Mr. Carasso up. There's an issue with probation.
Oh, okay.
I'm not
right.
sure yet.
So we're recalling Mr. Carasso, 22 CF 360, 24 CF 31.
He cannot live at the residence that he proposed at 1701 Needy Lane in Holmes County due to a city ordinance of 2,500 feet. So it will be denied by Holmes County Probation.
Okay, so where does that place us, Ms. Farkas? I mean,
Hold on, Mr. Carasso, don't say anything.
does he have a place to live?
No, Your Honor. If we could put it on docket day,
That's fine.
and I can speak with probation, see if I can help Mr. Carasso work something out. If we can put his case on for docket day, that'll give me a couple days to try to help him sort something else out.
Well, he just entered a plea. I mean, what are we doing?
So-
If I may make a suggestion, maybe, ma'am?
Yes.
Since we've agreed to the plea, but maybe if the court could officially hold off imposing the sanctions and reset it, so just accepted the plea, but then hold off imposing the sanctions until docket day. And that way he would still be pending sentencing, even though the plea's been entered, if that's acceptable to the court.
I would very much appreciate that, Your Honor, to see if there's anything I can do to
Okay, so
help.
then the court would vacate the imposition of the sentence.
But it's still maintain the acceptance of the plea?
Yes.
Thank you, ma'am. And
Okay.
I'll hold the score sheet then until imposition of the sentence,
Excellent.
although it is done now.
Yes, so just bring it on.
On docket day?
On
Would
docket
that be
day.
acceptable to everyone?
So, Ms. Farkas, is that what you're asking the court to do, to vacate the verbal imposition of the
Yes, Your
sentence that
Honor.
I announced? And I'm still accepting he's already pled, and the court still accepts his plea, but I will just
Yes, thank you.
vacate the verbal sentence I've
Okay.
pronounced in accordance with the agreement, and I will announce it on Monday, the
Okay,
17th.
thank you. I appreciate it. Thank you.
Sherry Clark is next. Your Honor, we're taking Sherry Clark out of order so that we can get Ms. Sandler's one remaining case dealt with.
Yes.
Miss Sherry Clark is number
100.
Thank you. 100 on the docket, 21 CF 3182 and 22 CF 2896. I did try to meet with her yesterday. I think she's aware I'm taking the expert deposition of the state of Florida on Friday. I would like to bring her back on docket day for plea or continue. It will be, I expect, the last continuance if we don't work things out, but it's always possible we'll be able to work things out on Friday depending on the deposition and so forth.
That's correct, Your Honor.
All right, so February 17th, plea or continue, and if it gets continued, would the parties be ready?
Yes, Judge, I haven't taken that deposition, it's an expert deposition, it's always a possibility that there would be a Daubert motion or something like that, but I would expect that we could get that heard and have a trial in April if we had to, but we're gonna see if we can avoid that. So.
Okay.
The
So,
state will be ready for trial next cycle. Your Honor.
okay. So plea or continue, if it is continued, it would be the last one.
Yes, Judge.
Okay, I'll see everybody on February 17th, that's Monday. Okay?
Thank you.
Thank you, ma'am. Thank you.
Stone Walters.
Your Honor, this is Charles Emerson. I actually waived Charles Emerson's appearance. He has another case under an alias, come on, under Stone Walters, so he is both Charles Emerson and Stone Walters.
Let me find
So I
both
intended
of
to
them.
waive his appearance.
Okay, let me find both.
So he
on the
wouldn't get
docket.
schlepped up here, yeah.
So-
So Charles Emerson, 24 CF 2509, 24 CF 453, and then Charles Emerson is also 24 CF 446, but that is under the name Walters.
Okay.
Figured they were like looking.
So I did waive his appearance in the Charles, in both cases, I believe, but he only got taken off the transport list as Charles Emerson, so here he is. Your Honor, there are about, by my count, about 30 witnesses who need to be deposed in these cases. We are starting to schedule the depositions, so I need a full cycle continuance. It's going to take a little bit of time.
Oh, yeah, I got you.
The state has no objection to continuing for depositions.
Okay. So one of these cases, two of the cases are getting pretty old, they're a year old.
Yes, Your Honor, they're fairly serious charges, and like I said, there are many, many witnesses involved, so that's why it's taking as much time as it is.
Could we approach them?
Yes.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Cyclone Bakery Cafe is 2 blocks from the courthouse on his Crestview historic
All
Main
right,
Street.
as to 24 CF 453, 24 CF 2509, both of those are under the name Charles Emerson, and 24 CF 446 under the name of Stone Walters. Those will be set on April 16th for docket day. Go ahead and, I know y'all will, go ahead and get the depots scheduled so we can get the cases resolved as soon as possible.
Yes, thank you, Your Honor.
Thank you.
Okay, I'll see you later. Okay. Those are, Steve's, Steve, those, I have a couple to address the more different cases, but we can do Steve's.
Would that be
So
enough,
That's fine for the state, Your Honor.
enough time to hear them both? And will y'all be able to
I just want to
argue
do
both
the
of them?
notice of hearing for the correct time. Should, Madam Clerk, can you advise, is Allaway at 3, or we just want to get the notice right?
I don't have the minute sheet right now.
Okay, I'm sorry. Judge, we'll, to be determined the exact time, but basically, sounds like maybe 4 o'clock or something.
I am seeing, I'm looking on March 20th, something at 2:30. It's Kaler with Mr. Garrett.
That's a DUI. It wasn't
And I see Allaway is at 10 o'clock in the morning.
So he's in the morning, okay, so why don't we just say 3 o'clock? And the court, obviously,
Or even 11 o'clock in the morning.
okay, 11 a.m., Your Honor?
My mistake.
Thank you. Sure. Now, we'll
Okay.
still see her on docket day just in case we get something done.
Okay, so let me just write this down. The motion to suppress will be March 20th at 11 in
Thank
the
you, Your Honor.
morning.
Great.
Okay.
All right, we'll see you Monday, 9-ish.
This Monday?
Yes.
Okay. Yes, sir. Thank you.
We may not get something done, but we'll try.
All right. Y'all have a good day.
Thank you.
Thank you.
Anderson is next.
Your Honor, I have some information for Mr. Anderson, based on a conversation I just had with the state. Could the court mute and I'll give him some information. With Creighton L. Anderson, 24 CF 2372, which is a new law, and 23 CF 2828, which is a VOP case. We don't have an agreement worked out, but the state is looking at his acceptances at Keaton, and also we just got an acceptance at Phoenix House, and it's possible we can work one of those out. And I think the state is willing to allow him to come back on Monday.
Yes, I'm reviewing this. It's going to be unlikely, but I will keep reviewing it. In the meantime, the state, we can leave it on for Monday, but I also would like to set up for a hearing pending my review.
You mean for, on a VOP?
Yes.
Were there, your judge, were there any grounds for the violation other than the new law?
Let me check.
I think it might have been the sole basis. The new violation, I think, is the sole basis.
Let me take a look and see. I am looking at the affidavit of violation of probation that was filed on October 16th, and it does say that the new charge is the basis for the violation.
Your Honor, may I have a moment with the state?
Sure. Do you want me to turn on the white noise for you?
No, I don't think it would be necessary.
Let's do it.
All right, Your Honor, the defendant has proposed an 18-month DOC global resolution. The state has indicated that would be acceptable. It encompasses the VOP, which is, I think, complicating matters. So he thinks that's in his best interest. So I'll write that up. If we can set him aside, I'll write that up. Awesome. Hey. All right.
Okay.
Do me a solid on Mr. Creighton. 18-month global? DOC. You can't do it, I'll get to it in a minute.
Jesse Anderson.
Hi, Your Honor.
All right, 23 CF 1127 and 24 CF 2097.
Yes, may I have a moment with the state? Because we had a back and forth on this one too. I
Sure.
apologize. Excuse me.
Yes.
Yes.
Sure.
Proposed 6 months for a global jail deal. So I'm going to write that up. That's acceptable to the state. So if we could set him aside too.
Okay.
You get your credit for time, sir.
My probation violation.
That will resolve 24 CF 2097, which is the new law, and 23 CF 1127 with the revoke and terminate. That's the BOP case.
Okay.
So I'll write that up.
Yes, sir.
Great.
Thank you.
And we'll recall you in just a
We'll call
minute,
you.
sir,
Thank
okay?
you.
May I have a moment? I'm sorry, Judge.
course.
I was having a bunch of meetings yesterday. It's kind of an unusual trial cycle, so.
No problem, go right ahead.
Can I give him some information? Would you mind?
Sure.
I know we're loading up, but we're hopefully going to get a lot of things done on Monday. Can we bring him back on docket day? The state needs to check on a couple things. And just for the record, the defendant's aware, we've been trying to locate the witness. There was a witness, Michael David Prentice. We haven't been able to find him. But anyway, we very well can work things out on Monday.
This is 24 CF 2533, Mr. Bessinger?
Bessinger.
Bessinger.
Yes, ma'am.
Thank you. So yes, February 17th for docket day, hopefully a resolution.
Thank you, Your Honor.
Thank you.
Next up is Reginald.
So that'll be a plea or continue, Your Honor. Please.
Plea or continue on Mr. Bessinger.
Thank you.
And
Your Honor, next is Mr. Bethune.
23
Reginald
CF.
Bethune.
23 CF 2580, 23 CF 2581, and 23 CF 2582.
Yes, Your Honor, and I had already relayed a basically an offer from the defendant that I got based on him talking to him, basically that if the state wasn't willing to take probation, would it consider a 24-month DOC offer? The state has not responded other than to say we can bring him back on docket day. On docket day, we have scheduled 3 motions in limine. It was probably a little bit on the ambitious side, but I was hoping they could be heard within the 30-minute limitation of a docket day. So that's why they're noticed for Monday. So he's coming back docket day, and hopefully we can either resolve it or hear those motions in limine if the court will permit. Well, I was in good faith thinking they could be done in 30 minutes, but I'm being upfront that that was a little on ambitious side for the docket day that I know is super full already. So, but
We're showing their schedule for the 13th.
So that would be Thursday.
okay, well, I guess I misunderstood.
Well, that's better.
But
We'll have more time on that day.
Well, do you want to bring him back on the 15th?
Yeah, that's fine. We just go straight to the.
We'll keep the motion in limine hearing that's scheduled, and he'll skip docket day, but we'll come back and we may resolve the case then. We may not, we may have to have the motions in limine.
So
Tomorrow, excuse me,
Thir-
Judge,
it's been
I
a long
apologize.
day. It's been a long day.
I did, no, there's no excuse.
No, I had to look.
The 17th. I thought he was coming back on the 17th docket day.
Do you want him on the 17th? There is a hearing at 9:30 on the 13th, tomorrow.
What I had intended to say, Judge, is I thought we had noticed these for February 17th. Is that incorrect?
Notice of hearing reflects February 13th.
February 13th? For 1:30?
Motion in limine, 9:30.
For 9:30? Okay, well, that's fine. Are you okay with that? That's what they're scheduled for. That's tomorrow at 9:30?
That's fine.
Okay,
Do
so,
you think it would be better if we continued it for purposes of maybe trying to work something out?
Yes.
Judge, do you have any time, because I want to give the state an ample consideration to consider the motions in light of his proposal?
Okay.
Does the court have any time where we could do the motions in limine in the 3 cases for Mr. Bethune next week?
let me
Sorry.
take a look.
Sorry, Judge, I got back pretty late from the jail, and I didn't have every single file with me. So.
Let me take a look.
The 18th, you have nothing scheduled in the afternoon.
How about the 18th?
That's much better, Your Honor. At what time, Your Honor?
Let's see. Okay, we have 63 cases set for the morning, but we don't have anything, I mean, I don't know how long it's going to take to get through 63 cases, but
Is this I'm sorry.
miscellaneous day.
So this is February 18th, next week. Okay.
Yes. Do you need March or what?
No, I would, that
Okay.
sounds good to me.
Okay, so then we have March 18th,
No, February 18th?
February 18th, sorry.
February 18 at,
He's, going to be transported, so
Yes,
we'll just
what if-
put 9 o'clock
9,
and we'll
yeah.
do
Right.
it when we can.
yes, Judge. Okay, thank you.
Sure.
All right, you're coming back then, okay?
So cancel tomorrow's latest.
So canceling tomorrow.
Cancel tomorrow
Okay.
in lieu of,
Or just the 18th?
he
Just
doesn't
the
need to come
18th.
docket day too, just the 18th.
Yeah. So motions in limine would be February 18th, that's next Tuesday, at, we're going to say 9 o'clock, but it's going to be a long day, so.
Thank you, Your
We
Honor.
will get to it as soon as we can. I'm going to probably try to, it'll be towards the end.
Right.
Because I will need to process as many people through as I can
Right.
before we have a lengthy hearing.
Right, and
relatively.
I styled them as motions in limine. There's substantial trial-related issues. I'm not sure if we'd be ready to have a trial this cycle, but I just think it's always good as early as possible to let the parties and the court know where we stand on some issues. So, here
Let
we
me
are.
ask court security about timing.
Yes, ma'am.
For the 18th, for transport, if we are intending to have Mr. Bethune's hearing in the afternoon, does it matter for transport purposes? I mean, he wouldn't need to be here bright and early if you're going to make several rounds.
Typically, it depends on how many inmates. So if there's only 20, 30 inmates, it makes more logical sense to bring them all at once. So he may be here earlier than needed. But if there's, like today where there was a lot, we had almost 90 inmates in total, it took a couple trips, so that's
So-
what it breaks down to.
Okay, so if you, who would
I
I?
don't know for next week who's being transported, it's a little too far out.
Okay, so I'll just let you know, I'll touch base with you, and then if you're going to have multiple trips, then he can be on one of the later trips.
Yes, ma'am.
Okay, so we'll say 9 o'clock, but the intent is that this is going to be heard towards the end.
Thank you, Your Honor. I appreciate the flexibility to maybe get something done. Thank you.
Sure, and we're canceling the hearing tomorrow morning, so it's February 13th, and we're just actually moving it to the 18th.
So we're, no promises. Thank you.
Next up will be David Bishop. Thank you, sir. Mr. Bishop.
Your Honor, Steve Medina with David Bishop. There are two motions that have been filed. One was a pretty significant motion to reopen and for amendment of the motion to suppress that had been heard by Judge Ketchel. And Your Honor had directed our assistants that that had to be scheduled with Judge Ketchel.
Yeah, I can't rehear something another judge already heard.
Right.
He would have to rehear
And
it.
I apologize to my client because it's been up in the air about scheduling. He hasn't received a copy of it. So that's just unfortunate, but he will be getting a copy of a very detailed motion to reopen and so forth.
Yes.
Oh, he says he has got it. Good.
Oh, okay, great. So yes, you'll have to coordinate with
Right.
Judge Ketchel to see how he wants to address
Right.
that, since it's a rehearing
Right.
of something he heard.
Yes, understood.
Mhm.
And so that date will be determined by Judge Ketchel's assistant. And then we also filed for Monday, docket day, I think, a notice of hearing on a motion that I filed, I think, on Tuesday. My days are confused right now, but it's a motion to compel the screenshots of Okaloosa County Sheriff's Office, their extraction report, and that we need that issue resolved. I don't know why we haven't gotten these screenshots that would allow me to have non-sensitive matter that I can take and go over with my client at jail, because he can't go with me to the sheriff's office and with my investigator and look at the extraction report himself. And I need that in order to, basically, there may be a round two on, if we don't prevail on the motion to suppress that we're asking for rehearing on, we will very likely have a substantive motion to suppress, and that we need the extraction report type information in order to fully understand issues of overbreadth and so forth that would be directed at the warrant itself, versus the procedural issue of the first motion to suppress had to do with him not getting a copy served.
Okay, so let me just take a look. You said the motion to compel is scheduled for the 17th? It's for docket day?
That's certainly what I think in my head, but I'm not very reliable at this point.
Ma'am, I don't see one in there,
And I
in the court file. I could miss it, but I don't see it.
thought my assistant had sent it out yesterday or the day before, but it's all running together. And she's not here today, so I know she's doing her best, as we all are.
If it was filed yesterday, it may not have made it to the court file yet, Because sometimes it takes at least a day to get in there.
Right, it is, and if Ms. Bond, it's also possible we can work it out. I've been emailing on this issue to the investigator.
And we've had some discussions about it, so.
So we hopefully can work it out anyway, so whatever day it's gonna be noticed on is a fairly short time frame in front of Your Honor, so I'll leave that to my assistant to communicate on that. And Ms. Basso and I may communicate, and it may move that, if I can get those screenshots.
Okay, well, whenever you want to set it, y'all just coordinate it and we'll
So
do
right
it.
now, just for control purposes, I think we need to do a full cycle April 16th so that there's a date in the record for control purposes, because there very well may end up being a trial in the case. We're not ready to cycle. We have one and probably two motions to suppress if we don't prevail on the first one that are going to need to be resolved before we can have a trial.
All right, what's the state's position regarding?
No objection, ma'am, to the request for a full cycle continuance. I know our assistants have been working with Ms. Van Buren to get that, Ms. Eileen to get that, Van Boxtel, what am I saying? Ms. Van Boxtel to get that set with Judge Ketchel. They are working on that for the rehearing on the motion to suppress. And as Mr. Medina said, we've been talking about the request for the other items that they wanted. So once we're sure what he's looking for, we'll work on that.
Okay, and the motion to compel that, I have no doubt you filed it, it just hasn't popped up in the system yet. Whenever you want to set that, just reach out to either the clerk or Amanda. And
That was on what, Your Honor?
the motion to compel, you mentioned.
Oh, yeah, like I said, I thought it had already been noticed, but I'll look into that.
It may have been, it's just,
Yeah.
there's a delay from when it gets filed to when I can see it.
Right, okay.
Okay, so in fact, yeah, just.
I think that this is the pretrial conference today for Mr. Bishop. He's saying he thought he had court again on Friday. Right now, I don't think we have any court on Friday for him.
There's no court on Friday, no
There is
criminal court on
I'm
Friday.
pretty sure there's no court for him on Friday, and I see no reason for him to come back on Monday docket day unless that's the time we're having the hearing on the motion to compel.
Okay, well, if you and Ms. Basso will just coordinate on that and then
It should have
make
already
sure
been.
he's on the
It
docket.
should have already been noticed, and
It may have been,
Yeah,
I can't see it yet. It probably was, I don't have access.
Yeah.
So,
So
okay.
he may be coming back on docket day coincident with a motion to compel hearing.
If not, then perhaps he could, work something out on a different day next week. I mean, we
Okay.
have
I
the
will-
18th and we have the 20th. I don't know
I'll
what's
check into
set on
it.
the
Thank you.
20th.
Thank you.
Okay?
Malik Bradshaw?
Steve Medina with Mr. Malik Bradshaw. Mr. Bradshaw's number 93 on the docket.
Yes.
21 CF 2374 is the BOP case. The new law is 23 CF 2658. And as the court's aware, the court is considering its decision on our motion to compel. And at this point in time, I think it's probably necessitates a full cycle continuance, but should we bring Bradshaw back on Monday? I mean, I know that I'm just representing to the court. My understanding is that it's not going to plea out based on what he's told me. That could always change, but pleas always have to have that's the decision of the defendant, not the lawyer. So I think if it's going to be a trial, it would probably have to be next cycle. And obviously, the whole thing could be obviated by the court's decision on the motion to suppress.
I was hoping to have you in order today, but I was bogged down trying to get through the docket and didn't get that finished. I'm hoping.
Should we bring him in for a status or something like that?
Yes, how about Monday?
Okay,
And
all right.
worst case, I'll do the order. You'll have an order prior to Monday.
Okay, so a plea or continue docket day will return, okay, this Monday. Okay? Thank you.
Yes.
Thank you, Your Honor.
Thank you.
Daquan Bridges.
Sir? 18 months of prison. Yes, 18 months CFC. And our Steve Medina with Daquan T. Bridges, 24 CF 2673. Your Honor, we either have or are setting depositions of the alleged victim and 2 law enforcement officers. And I do need a full cycle continuance, please. I think this is his first time out.
There's no objection from the state, Your Honor.
All right. Hi, Mr. Bridges, how are you?
I'm fine.
I was the dependency judge until Judge Ketchel and I switched, so I have had Mr. Bridges in a different case. So I will grant that continuance. That would be, do I need to put this on the 14th?
Yes,
In
Judge.
case, I'm not sure of the situation, but.
Yes.
I'll say the 14th. We can always look at the date and move it to the 16th if we need to.
I'm sorry. Okay.
April 14th?
Is that's in custody or that's out of custody?
I think I'm supposed to be setting everything on the 14th, and then we move people at the
okay.
last
I
minute.
didn't know that. I didn't realize that. Okay.
You know,
Okay.
that's sort of the default, but some of the
Gotcha.
people who have come
Okay.
before me today, I'm certain they're still going to be in custody, so I went ahead and put them on the 16th.
So
And I
we
just
say the
haven't.
14th and they automatically slide to the
They did,
16th
anybody
if they're
that
still in
needs.
custody.
Correct.
Gotcha.
Anybody that's in custody right before the 14th gets moved anyway.
Okay.
Yeah.
All right, we'll see how they do. Thank you, Your Honor.
Sure.
Jose Briones.
Your Honor, Mr. Jose H. Briones is before the court, 24 CF 1302. There's also a VOP case, 20 CF 1568. I think it predates Your Honor, but I think the state's position is that I know the state's position is that because the new law violation is the sole basis for the VOP, that we could do the jury trial first in 24 CF 1302. In any event, we have set or are setting 4 depositions, 1 law enforcement officer and the 3 witnesses. We do need a full cycle continuance to complete that.
Your Honor, the state would request,
How does this, or are you finished?
No, Judge, I'm sorry.
Oh, go ahead.
Because I realized, I met with, it was going to be 19 people, and I only met with 15 or 16 people yesterday afternoon, and I had a lot of notes. May I have a moment with the prosecutor, Your Honor?
Sure. In fact, well, yeah, go ahead. I was going to say we could take a quick break, but go ahead since your client's there.
Agreement between the parties. I need to go forward with those depositions. The defendant's position was he wanted 12 months. He was willing to do 18 months, but the state is not willing to do less than 36 months, so we don't have of course, legitimate plea bargain at this point. I intend to take those depositions. May I have your indulgence, Your Honor? He's trying to whisper to me.
Sure, let me turn on the.
Carry one more time, Judge? I'm sorry.
Sure.
So there's Your Honor, we're not going to have any more negotiations. The state's best offer, at least for purposes of today, state's best offer is 36 months. He was offering 24 months. We're not going to be able to craft a deal today. So please continue to April 14th. We'll be conducting depositions and be ready for trial next cycle if we have to.
What is the state's position?
Your Honor, on 2020 CF 1568, the state is requesting to set this for a VOP hearing with subs as soon as possible.
Okay.
That, Your Honor, just for the record, like I stated, that wasn't the state's position back in, I think, December, but is the state changing its position?
Yes.
Okay, well, that's its prerogative, I guess.
So if they want to try the VOP first, then they certainly can do that.
I do think that, Your Honor, it's the same issues, so we're going to still need the depositions in preparation for the VOP hearing, so I don't really see how we can set the date certain when we don't know the deposition dates. I don't know them. But, you know, if we want to set it for VOP without subpoenas earlier, like in March or something, we never know, we maybe work something out before or something. But I don't know when the depositions are going to be. I'm just hesitant to say that we should set it for with subpoenas, but do you think we'll get depositions done before? Well, it depends on when the... Sorry, Judge, we have all these scheduling things trying to hash out in open court. I know it's not ideal.
No, that's, how long does the state think you'll need for the VOP hearing?
An hour, Your Honor, at most, probably.
Okay.
I cannot agree with that, Judge. I think it's there'll be video. Basically it's a mini DUI trial. There are 3 lay witnesses, well, one of whom is a Florosa Fire Department representative. There's the main Leo, and there's all sorts of videos. So I think we're talking more like 3 or 4 hours. You know, basically it's a DUI trial in the form of a bench trial with a different standard of proof, of course. I'd say a half day. But if we do VOP without subpoenas, it can kind of be a status, and who knows, we may work something out. So.
Well, what I'm going to, rather than me sit here and try to find when would be the best time to set that, I'm going to let Amanda coordinate that and get
Okay.
you a hearing time. So you need 3 hours, 4 hours?
I think we could say 3 as long as the court knows we'll be as efficient as possible. What concerns me is that if you're literally watching officer video in real time, I mean, that might be I don't have a ticker tape here, but that might be an hour and a half right there. I don't know. And I would certainly be showing it all to the jury, or the state would, maybe even twice, but with Your Honor, only once. So I would say 4 hours to be on the safe side.
Okay.
4 hours is fine, Your Honor, just so it's be clear that this will be with subpoenas whenever we do get a date from Ms. Bailey.
Okay.
Okay.
So if y'all could reach out to her, I'm making a note, but I've got so many notes to give her. If you could reach out to her and ask her for that time, and then I'm going to make myself a note to get with her to find some more dates to offer, because they're...
And they've got to coincide, it's got to coincide with deposition dates, which our assistants will know because they're working on that scheduling too. So we'll make it coordinate, Your Honor. Okay. And if in the event that it's that after deposition something can be worked out, we may be asking the state to come in earlier or something. You never know.
All right.
Okay. Thank you, Mr. All right, man. Thank you.
So, well, when do I need to set Mr. Brioni's for a, because right now we haven't set anything, so let me give him a date. I'm gonna go ahead and set Mr. Brioni's on the 16th of April.
Oh.
I mean, I've got to set him for something.
Oh, okay, so April, just for a status, is for a.
Yes, but I'm hoping we can.
Is
get
that April 14th then, just
16th.
continue?
We'll just put the 16th,
Okay.
because I don't anticipate him.
For,
getting out
okay,
before then.
April 16, that's basically for his pretrial, continuation of his pretrial.
Pretrial, but I'm going to try to get that VOP contested hearing set prior to then, but I need to set some sort of control.
Right, and we'll be in
on his
touch
new
with,
law.
we'll be in
Yeah.
touch with your assistant on the to-be-determined VOP evidentiary.
Yeah, so that'll be, definitely on the new law, we will be back on the 16th of April.
Okay.
But I'm hoping we can get the VOP resolved before then, if not, it'll be the 16th.
Yes, Your Honor, thank you.
Okay.
Motion to compel discovery. We can't have it. He wants a full export copy of the solid report. You can't have it.
Yes, ma'am.
Your Honor, Steve Medina with Bernard X. Buchanan, Mr. Buchanan's 24 CF 2283. We have taken depositions. I gave the state something to consider with him. Do you think we could bring him back? I know you're gonna have victim contact.
It's unlikely my victim's gonna want to go forward with that proposed offer, but I do need to make contact and go over that with him, so.
Okay.
We can put him on Monday, that's fine.
Okay, well, it won't hurt if that's okay. Let's return on docket day, and it'll be plea or continue. He's given, through me, a proposal, and the state wants to have victim contact, and if it works out, that'd be great. If it doesn't, we'll continue.
So as to the case numbers are 24 CF 2283 and 23 CF 25. 23 CF 25 is a failed pretrial intervention, correct?
I'm not familiar with that one. I maybe should be, but is that for the same? That's for the same individual, right?
Bernard Buchanan?
I don't have a file for that. Let me see. Is that in the?
That is correct, Your Honor, it was with the plea as well.
Yeah, it's 23 CF
Yeah.
25.
I don't know when that was, I don't know when, is that a PTI recall? I mean.
Yes.
A PTI recall, so that's a case that, standing here, I don't have the file.
Okay.
Maybe I'm familiar with it, but the part of me that's here today is not familiar with that, so I apologize.
Well, I mean, there's the 24 CF 2283 is the new law.
Right, and we've done deposition in that case. We're trying to locate the witness. I'm also reaching out to make sure there's not any video that can be obtained through my investigator, but basically, we need to see if this eyewitness can be found. So far, the best we heard is that maybe he's moved to Indiana, so.
Okay, so as to this older case, the 23 CF 25, there was already a plea entered, so a failure of pretrial intervention results in, goes straight to sentencing. So just putting everybody on notice of that.
Could we continue that for, at least for status, to run with this one until I can at least check into it?
Sure. So we've set both cases on February the 17th, which is Monday, docket day.
Okay,
And
good.
on that day, what I'll do is go ahead and set a sentencing on the older case. Probably pretty quick.
Okay, Your Honor, thank you.
Sure, in fact, probably, possibly that same week.
Yeah, just so Mr. Dean is aware, the reason he doesn't recall is because it was actually a private attorney, Lynn Switek. Lynn Switek was the one that did the PTI with him. That's why we allowed me to recall it.
Oh, okay, so it's Mr. Switek's case.
And yet, technically, that would be our position, because the PTI was done through Mr. Switek. If it's been reset on the docket, it would need to go back to him.
Right, so usually that's gifted to the public defender, so we'll see how that transpires, but I'm
Okay.
not real optimistic that Mr. Switek will be taking on that responsibility by the time it's all over. Huh? Right.
Okay, well,
So I guess he needs to be here on Monday to discuss that PTI recall too, and then.
absolutely, and then we'll be scheduling sentencing on the older case.
Thank you,
Yeah.
Mr. Gates.
Yes.
Just so Mr. Reed is aware, he actually, it was a plea to a lesser included misdemeanor.
Yeah, it is a misdemeanor.
Okay.
It's a little easier than what he originally was charged with.
Okay.
Hey, I think the only thing that I was missing was.
Okay, that's fine. I'll look into that, Judge, and I'm sorry. I may have that somewhere in my files and not realize it. I probably
I
do.
understand why that one wouldn't be on your radar. It's on my docket, so
Okay.
that's. why.
I apologize for not knowing about it, Judge. We'll bring him back on Monday and look
Okay.
into it. Okay?
All right, so February 17th for both of Mr. Buchanan's cases.
Okay, thank you.
After this case, we will take a brief break and then come back. I know that there were a couple of attorneys who were working on some agreements and talking to clients, so.
May I have a second?
Sure.
For CF 2331. I did call for him at the jail yesterday. He didn't realize it. My understanding is the state is looking for the alleged victim, and I'm not sure if there was a witness too. I think there was. I think it's just the alleged victim, and hasn't been able to find that person. Were you thinking we would just I guess there was maybe an attempt to locate a witness too.
Yes, there's been an attempt to locate both. I do have a pending request to my investigator at this point. It's marked working, so she has seen this, to locate my victim. I will have an answer by Monday. If I can't find my victim, then, this case will be resolved.
Your Honor, okay, so that by Monday?
Yeah.
Okay, good.
Okay, February 17th for docket day, and we'll know where the case is going then.
Okay, thank you. All right.
All right, why don't we take about a 10-minute break? Actually, do we have any, is everybody else just people who are waiting on agreements?
Yes,
Okay,
ma'am.
that'll give you, do you need more than 10 minutes to talk to them? And I know Mr. Medina has at least one to recall, and I know Ms. Farkas did too.
I've got 2 recalls and.
And I'm ready on mine whenever we come back from the break, and then I think Mr. Medina should be set too.
So I'm getting assistance from my colleagues on, Mr. Gates has already drafted Creighton Anderson, so I need to talk to him, and then the other.
I think it's Jesse Anderson might be the other one.
Jesse Anderson also has a plea.
Yes.
So Ms. Farkas has drafted that one, so I appreciate all their assistance, Judge. I will need to talk to both of those individuals. Would it be advantageous to
Yes, I'm going to call a brief recess and then come back in 10 to 15 minutes, and hopefully we'll be ready to wrap up the remaining cases.
Judge
Thank
Clark, ma'am, I don't have anything further. May I be excused?
Yes, thank you.
Thanks so much, both.
Back Home Bakery Cafe is 2 blocks from the courthouse on his Crestview Historic
CF2734.
Yes. It doesn't include the misdemeanor, but also pleading to trespassing. Do I have that?
Did you make sure it was okay without offenders?
I did not, but I'm sure we'll be fine with it.
Just gonna let it out of jail.
Yeah, she'll be fine with it. Yes.
He's coming out right now.
I don't know if you want to write in there. Your Honor, this is Mr. Davis for recalling his case. The plea agreement here will include the felony case that's before you, as well as his misdemeanor, which I'm just writing it at the top. His misdemeanor, which is 25 MM0184. I signed it. I need to have the state attorney sign the plea agreement and to have Mr. Davis sign the plea agreement. This will not be a downward departure. He does not score prison time, but we do have a score sheet.
All right, thank you.
This is your copy, okay? And I'll give a copy to probation. Okay, so I'll just have Mr. Davis sign it. Okay, so it's just exactly what we talked about. All right, Your Honor, if I may approach with the plea agreement. Oh, hold on. Sorry, once again, we are not mathematicians. Or you're just a bit basic. Okay. Can I correct you on this? Thank you. Okay.
Thank you for your patience, Your Honor.
So, as we went over, you still don't score prison. I gave you 0.2 points. Okay.
Thank you.
Your Honor, I did discuss the score sheet with Mr. Davis in the back.
Thank you.
The only addition was the misdemeanor added 0.2 points. That is the misdemeanor case,
And is that in Judge Schlecter's division?
Yes, it is, Your Honor.
Okay, he will be perfectly happy with me to resolve his case.
Yes.
Okay.
So in 24 CF 2734, counts 1 and 2 will be adjudications of guilt. Count 1 is a felony grand theft. There will be 24 months probation, $515 in court costs, $150 public defender fee. Count 2 is just a first degree misdemeanor. That will be adjudication of guilt, credit for time served. 25 MM 0184, a single count of misdemeanor trespassing. That'll be adjudication of guilt, credit for time served, and no trespassing at the address listed there.
And would there be, what would be the costs on the misdemeanor case?
Oh, I apologize. It's $270 in court costs. And could Your Honor read the address that I put for the trespassing? I want to make sure that probation has it correct.
Yeah, 'cause this ain't correct.
Oh,
Yeah, that one isn't correct. We've had
is it
edited.
1047
Yes.
10th Street?
Yes.
Like the number 10, 10th Street, Shalimar 32579?
Yes, that's it.
Okay, $270 in court costs, and then there would be a, what, $50 PD fee? Okay, great, thank you.
And I just want to make sure, adding the court cost for the misdemeanor, does that change your decision to accept the plea? Okay, just want to make sure.
It says on here, waive cost of prosecution.
I definitely meant probation. I'm getting a little bit cross-eyed, Your Honor.
Is probation okay with waiving? Okay. Oh, and supervision.
There we go. No, you're good.
And the cost for the single case, or when they go on supervision?
Yes. let's see, how can we, Ms. Farkas, how can
Yes, Your Honor.
Mr., is it Mr. Strauss or Ms. Gaynor? I don't know, who has this case?
Mr. Strauss.
Okay. How can we include or can we include the misdemeanor costs to be paid during the probation, or is that going to mess it up?
I have, in the past, I've written it as like to be paid during the term of probation in the felony case, or we can put 24 months to pay costs, and that would cover it because that would be the term of probation.
Okay.
Correct. The state's not interested in like having it on the book for the costs. It's not gonna violate them.
Okay. Well, then in that case, what I could do is just for the misdemeanor, say, work out a payment plan within 30 days, get on a payment plan, and then you can pay it on a payment plan on the misdemeanor.
Perfectly fine.
And then felony just within the time frame of probation.
That's correct.
I was just letting Mr. Davis know that after he meets with probation in the morning, he can go to the clerk's office to sort out a payment plan for the cases.
All right, sir, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. If you'll state your name for me.
Demar Davis.
Thank you, sir. In case 24 CF 2734, you're charged with 1 count of grand theft. That's a 3rd-degree felony, and 1 count of resisting an officer without violence. That's a 1st-degree misdemeanor. In case 25 MM 184, you are charged with 1 count of trespassing, which is a misdemeanor. Have you had a chance to talk to your lawyer about all of those charges and any possible defenses you might have?
Yes, ma'am.
Did you read and sign the plea agreement?
Yeah, I did.
Is this your signature on the last page?
It is.
Do you understand the rights you give up when you enter a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Has anybody forced you to enter the plea?
No, ma'am.
Are you happy with the services of your lawyer?
Yes, ma'am.
Did she answer all of your questions?
She did.
Have you had any drugs or alcohol or anything in the last 24 hours to affect your ability to understand what you're doing?
No, ma'am.
I have a score sheet that shows 18.2 total sentence points. Any objections?
No, that's correct, Your Honor.
Any DNA?
No, Your Honor. Not that I know of.
I do find a sufficient factual basis based on the arrest documents. And sir, if you are not a U.S. citizen, do you understand that the plea will subject you to deportation?
I do.
In 24 CF 2734, how do you plead to 1 count of grand theft and 1 count of resisting without violence?
No contest.
All right, and in 25 MM 184, how do you plead to 1 count of trespassing?
No contest.
I accept your plea in both cases. I find it was freely and voluntarily entered, and there will be an adjudication of guilt as to all of those charges in both cases. And count 1 in the felony case will be 24 months probation with the standard terms and conditions, $515 in court costs, $150 public defender fee, and probation has graciously agreed to waive the cost of supervision. That'll save you about $40 per month. And count 2 will be just credit for time served. And in the misdemeanor case, 25 MM 184, adjudication of guilt, credit for time served, no trespassing at, let me make sure this is right, 1047 10th Street, Shalimar, Florida 32579.
Yes, Your Honor, that's correct.
Okay. And $270 in court costs, $50 public defender fee. Go see the clerk of court within 30 days after you're released to work out a payment plan on those costs, and that way your license won't be affected by it, okay? And you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I will appoint one for you. Good luck to you, sir. You need to report to probation. Is this the only thing holding you in jail?
Yes, Your Honor. So he should be released today. It probably won't be in time to go to probation today, but then first thing in the morning.
Go see them before 9:30 in the morning, okay?
Creighton Anderson will be next.
Recalling, if we may, Creighton L. Anderson and 23 CF 2828 and 24 CF 372. He's been over the agreement. Travis, you usually have him sign the one that goes back with him?
That's his copy.
Yeah, that's yours.
Thank you.
Gotcha. Your Honor, I need this, make sure the state gets to sign this. Lower score. Yeah, I got you. It's going into the court file, so I wanted you to see it again. I've got a revised score sheet.
Got one too.
Oh, okay. All right, well, I'll use yours. Thank you. Thank you. Your Honor, may I approach with the agreement and score sheet? We don't question the score sheet.
Okay, great.
Mr. Medina, I think you and your client still need to sign.
Oh. I'm so sorry. All right, man. Ready to go?
Yes, sir.
I'll date it for you.
Thank you.
Yes, sir.
Oh, yeah.
Thank you. Thank you. All right. Yeah, trying again. Thank you.
Thank you.
Thank you. Hey, Your Honor, by the way, on the score sheet, I went through that pretty carefully and saw there might be some significant issues with when he pled out a VOP case. The state looked at it, and yes, there were major corrections, so we appreciate that. It's all rectified in the current score sheet. Under the agreement, Your Honor, there's going to be in 23 CF 2828. Of course, he's admitting the VOP. It didn't say admit the VOP, but reinstate and terminate probation. He's admitting that VOP. In count 1, 18 months DOC, concurrent with each count and case, with credit for all time served. On counts 2 and 3, which were misdemeanor VOPs, it's credit for time served, $100 cost of prosecution, $150 public defender fees. And 24 CF 2373, there's 18 months DOC, that's the new law, and that's concurrent with each case, with credit for all time served. And he understands the VOP credit is going to be different than the new law credit. He really needs to pay attention to the new law credit. He's aware of that difference. 515 court costs, 150 PD fee. The defendant would ask for 24 months from date of release to pay the outstanding court costs before they are sent to collection, Your Honor.
And, sir, if you'll go see the clerk within 30 days after you get out and get on a payment plan, as long as you're current on your payments, then it won't affect your license.
All right.
Okay.
Thank you very much, Your Honor.
Sure. So I'm going to swear you in. I'm going to ask you some questions. Was Mr. Anderson adjudicated already on the 23 CF 2828 case?
Yes, Your Honor.
Okay. All right. So, Mr. Anderson, if you'll just raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do, Your Honor.
Thank you. You can put your hand down. If you'll state your name for me, please.
Creighton Lee Anderson.
Thank you. So in 23 CF 2828, You're here on allegations that you violated your probation, and in case 24 CF 2372, you're here on one count of grand theft auto, which is a third-degree felony. Have you had a chance to talk to your lawyer about the allegations that you violated your probation in 23 CF 2828 and then the new charge of grand theft auto?
I have, Your Honor.
Did you discuss the plea agreement with your lawyer?
Yes, Your Honor.
Did you read and sign the plea agreement?
I did, Your Honor.
And is this your signature on the last page?
Yes, ma'am, it is.
Do you understand the rights you give up when you enter a plea?
I do, Your Honor.
Are you happy with the services of your lawyer?
Very much so, Your Honor.
That's good to hear. Have you had any drugs, alcohol, medicine, anything in the last 24 hours that affects your ability to understand what you're doing?
I have not, Your Honor.
And I have a score sheet that shows 60.4 total sentence points with a lowest permissible sentence of 24 months, 24.3 months actually. So this is a slight downward departure. Is that right, State?
Correct, Your Honor, it's a slight downward departure.
Okay, and that's based on the state's?
As a part of the legitimate uncoerced plea agreement, Your Honor.
Is there any DNA?
No, Your Honor.
All right, I do find a sufficient factual basis based on my review of the arrest report. And sir, if you're not a U.S. citizen, do you understand that this plea could subject you to deportation?
I do, Your Honor.
And are you admitting to the allegations that you violated your probation in 23 CF 2828?
I am, Your Honor. Yes, ma'am.
All right. And how do you plead to grand theft auto in 24 CF 2372?
No contest, Your Honor.
All right, I accept your admission and your plea. I find that they were all freely and voluntarily entered, and I'm going to sentence you in accordance with your plea agreement. There will be an adjudication of guilt on all charges in both cases. In 23 CF 2828, we are revoking and terminating probation and sentencing you as follows. Count 1 will be 18 months state prison with credit for all time served. In counts 2 and 3, which are misdemeanors, credit for time served. There will be a $100 cost of prosecution fee, a $150 public defender fee. All counts will run concurrent. In 24 CF 2373, sentence of 18 months state prison with credit for all time served. That will run concurrently with all counts in the other case. $515 court cost, $100 public defender fee. Let me make sure those figures are right. Okay, great. And sir, if you will go and see the clerk within 30 days after you get out and get on a payment plan, then they won't revoke your license if you stay on your payment plan. And you have 30 days to appeal the judgment and sentence of the court, and if you cannot afford a lawyer, I'll appoint one. Good luck to you.
Thank you very much, Your Honor.
Thank you.
And
Thank you.
Jesse.
Your Honor, Jesse A. Anderson is coming back on 23 CF 1127 and 24 CF 2097. Just want to make sure he's seen his score sheet. I know that we've already been over it, Your Honor.
Yes, sir.
May I approach with the
Yes.
agreement, Your Honor?
Yes.
Just a substitute copy for you that gets the numbers right.
Yes, sir.
Thank you.
Yes, sir. Thank you. So this one's no good, right? This one?
Yeah, that's fine. You can just throw it away or
Yes,
give
sir.
it to me. And you do need to sign. You ready to sign?
Yes, sir.
Okay.
Okay. Thank you.
Thank you.
Where you say right there?
1 through 3, and then 4 and 5.
Okay, okay, yeah.
Because there's 3 possession control.
Yes, sir.
I'm going to look at your copy too. And announce announcing it. I'll give it back to you in a minute. May I approach, Your Honor?
Yes. Thank you.
Thank you. Your Honor, we'll see that I interlineated that on the
I don't think that's this one right here.
I'm sorry, Judge.
That's okay, it's been a long day. I think I got it.
Okay, so we've got 23 CF 1127. He was previously adjudicated guilty. He's admitting the VOP. There will be count 1. That's the sole count at this point. It's a misdemeanor, lesser included. 6 months Okaloosa County Jail with credit for all time served on that misdemeanor VOP, concurrent to all other counts. 150 public defender fees, 100 cost of prosecution, 24 months to pay upon release. In the new law case, 23 CF 2097, there were actually 3 possession of controlled substance, so I made the corresponding changes to clarify that. So counts 1 through 3 will be adjudicated guilty. 6 months Okaloosa County Jail, credit for all time served, concurrent to all other counts and cases for that matter. $100 PD fee, $100 cost of prosecution. No, that one should be, it's a controlled substance, so it's, instead of 100 cost of prosecution, that should be 615 court costs. My apologies.
Is that right, 615? Okay.
Can the court make that
Of course.
change? You understand the change?
Yes, sir.
24 months to pay upon release. Count 4, adjudication of guilt, 6 months Okaloosa County Jail, credit for all time served, concurrent. And then count 5, which was a second degree misdemeanor, would just be adjudicated guilty with credit for all time served.
And there would be a mandatory suspension of driver's license that goes along with counts 1 through 3, correct?
Are you aware of that?
Mm-hmm.
That's in the
Required
fine
by-
print. Let me make sure he understands that.
Okay.
Your Honor, he advises that his suspension, that he already had a suspended license, so it's, was court cost related. This will be because of controlled substance. There wasn't a DUI involved in this. Would the court consider entering one of those business purposes only orders that wouldn't do anything other than say the court doesn't oppose him getting a business purposes only permit if he's otherwise qualified under state regulations?
Yeah, so what that means is, if you're adjudicated guilty on counts 1 through 3 in your new law case, possession of a controlled substance, it's automatic that your driver's license will get suspended. It's in the statute. There's
Yes.
nothing I can do about that.
Yes, ma'am. How long?
It's either 6 months or a year. I
Yes,
cannot
ma'am.
remember right now.
It's a year.
It's a year.
Yes, sir.
Okay. So that's mandatory, and I can't take that away.
Yes, ma'am.
I also cannot tell Department of Highway Safety and Motor Vehicles to give you a business purposes only license. What I can do is state that I don't object to it.
Yes, ma'am.
So as long as you qualify and you meet their criteria to get one, then they'll know that the court doesn't object, but I can't make them give you one.
Yes,
Okay?
ma'am.
So that's between you and them.
May I approach your Honor?
Yes. Mhm.
I wrote both case numbers down.
Thank you.
Thank you.
All right, sir, if you'll just raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you. You can put your hand down. Will you state your name, please?
Jesse Allen Anderson.
Thank you. So, sir, you're here on allegations that you violated your probation in 23 CF 1127 and also new charges in 24 CF 2097. Those new charges are counts 1 through 3 are possession of a controlled substance. That's a third-degree felony for each count. Count 4 is driving while license suspended second or subsequent conviction. And count 5 is leaving the scene of a crash involving more than $50 of damage. That's a misdemeanor. And sir, have you had a chance to talk to your lawyer about the allegations you violated your probation and all of the new charges in 24 CF 2097?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the plea agreement?
Yes, ma'am.
Is that your signature on the last page?
Yes, ma'am.
Do you understand the rights you give up when you enter a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Has anybody promised you anything that's not on your agreement?
No, ma'am.
Is anybody forcing you to enter the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, anything in the last 24 hours that affects your ability to understand what you're doing?
No, ma'am.
I do have a score sheet that shows 27 total sentence points. Any objections or
No, Your
corrections? All right. Any DNA?
No, Your Honor.
I do find a sufficient factual basis based on the arrest report. Sir, if you're not a U.S. citizen, do you understand that the plea will subject you to deportation?
Yes, ma'am.
Are you admitting to the violation of your probation in 23 CF 1127?
Yes, ma'am.
And how do you plead to counts 1 through 5 in 24 CF 2097?
No contest.
I accept your plea in that case and your admission in your violation of probation case. I find that they were all freely and voluntarily entered. I will adjudicate you in accordance with your plea agreement. In 23 CF 1127, there's a previous adjudication of guilt, and you are sentenced to, well, probation is revoked and terminated. And you're sentenced to 6 months in the Okaloosa County Jail with credit for all time served, $150 public defender fee, $100 cost of prosecution. And if you will go and see the clerk as soon as you get out, well, within 30 days of that, and work out a payment plan, then they will work with you
Yes, ma'am.
to get those taken care of. After 24 months, if you haven't done that, they'll go to a lien. And in case 24 CF 2097, there will be an adjudication of guilt on all counts. As to counts 1, 2, and 3, a sentence of 6 months in the Okaloosa County Jail with credit for all time served, concurrent to all other counts and the other case that I just mentioned. So all counts will run concurrently, all cases concurrently.
Yes.
$100 public defender fee, $615 court costs. Again, go see the clerk, work out a payment plan. As long as you're current, then they won't put these costs against your license. Then as to count 4, that would also be 6 months Okaloosa County Jail, credit for all time served, concurrent with all the other counts. Count 5 is credit for time served. So all counts will be concurrent. Did I leave out anything?
No, Your Honor.
All right. And sir, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you.
I see it.
And I'll fill out this order on the driver's license to state I don't have any objection to you getting a business purposes
Yes,
license.
ma'am. Thank you.
Thank you. Good luck to you.
Good luck.
Thank you, Steve.
I had a few more on my docket that maybe I just forgot to check off, but
Yes, Your Honor, there are a couple of my cases who I waived the client's appearances.
okay.
I don't know if you just want to read the ones that you have to make sure that I don't miss anyone.
Yes, let's double check each other and Madam Clerk can tell us if we're missing any.